Welcome to Looking at Legal Stuff. Today we have two clips and a motion for contempt with a woman who gives the court one guilt trip after another, all while claiming she didn't want to insult the court with pocket change when she didn't pay anything at all. Dad's lawyer points out that it seems like she wants to play stay-at-home mom to her new baby, but she expects the wrong father to pay all the bills, and with $5,000 in arrears, it's time to seriously consider jail. Let's see what the judge thinks.
Gilliam and Gilliam, 20-3-004298.
That matters. Ready?
And I'm sorry, Stockwell. It's not changed in the system, so I always refer to you as Gilliam until I see you on Zoom, Ms. Stockwell. So I apologize. We are here to review the amended tax return
and payments. So we're really in the same position that we were the last hearing. The court entered the contempt back in late June, ordered Ms. Stockwell to file her amended tax return, to file a copy with the court, provide me a copy. That has not happened. There's no evidence of her attempting to make that happen, of her making any efforts really whatsoever. I do not see that at least anything that she's filed indicating that she's making payments. So really we have zero progress and zero attempts at progress. And again, in a case, and if the court will recall, my client tried to prevent her from filing this tax return wrongfully back in January. We waited, we made lots of efforts over about 6 months to get her to comply. She just was obstinate and refused despite a very clear order. We're really in the same position. There is no excuse on this one for something that's really straightforward. It is taking time and money out of my client's hands and out of the hands that are the ones that are responsible for feeding and caring for the children. So kind of similar to the last case that you heard, my thought is to kick it out 2 weeks, but if it's not done at some point, the rubber's got to meet the road and jail time is appropriate. I don't want to do that. I want compliance. But if Ms. Stockwell is just going to ignore the court's order, I don't know what other options we have.
Ms. Stockwell, can you update me on the amended tax return?
Yes, Your Honor. I did get that tax return amended on the 9th. In the wee hours of the morning. I was working on it over the weekend after I had dropped off the kids from my visit. I did get them amended, but after amending them, I was left with no money for gas money to get back down to file in the court system or to present Ms. Baldwin's office with a copy of this. I've also made a $90 payment to child support as soon as possible. I had to wait for my check to hit last week for that to go through because again, we were in the hole and didn't have money to be able to get down and get any of that or to put any money forth for child support. And I think that was the topics. I'm sorry, my pregnancy brain is getting really bad.
All right. And I'm assuming, Ms. Baldwin, you haven't seen any payments come through at this point are these payments going through DCYF?
Yes.
Okay.
And so my concern, very similarly, I'm going to throw out my hands and make excuses. Those excuses just really fall flat. I couldn't get down there for gas. I have email. I have mail. The court has mail. She could, if she says she did it on the 9th, we're 9 days past that. She could have put it in snail mail and we'd all have it by now. And she did, which leads me to suspect that she hasn't done it. So again, the concern there just isn't an excuse to not have, paid 60 cents for a stamp and put it in the mail. And so no excuse there. I don't think she's made a payment. She says she's going to make a payment ASAP, and a $90 payment is not cutting it. Again, there's not any excuse that she has. The child support order is, I believe, $480. And hey, I'm going to pay what amounts to a 20% of that isn't acceptable. She's not providing you any sort of plan for how she's going to even pay current support. It's just, I'll pay what I want to pay. that's not what the order is. You have to pay the court ordered amount. And so again, we just have somebody says, I'll do what I want. And that is not appropriate. And so same request over 2 weeks, she needs to provide it. And if she doesn't and doesn't start making real payments, then jail time seems to be the only option to get her attention. Not what I want, but when people just sort of thumb their nose at the court, at some point we have to get their attention.
Unfortunately, the $90 was garnished from my paycheck and was half of my check. Therefore, we do not have the money to put forward yet. My husband does get paid this week, and we can put more towards it. But I have paid as much as I possibly can up to this point, as again, with all of the bills and everything coming in. I am more than happy to provide proof of our bank statements or anything needed. And I have contacted Mr. Gilliam to get an email to send those, and he has refused. So I have not been able to email Ms. Baldwin. I can't find it online. I've looked in many places. And I'm not making excuses. I'm genuinely trying to do this. This has been a very big stressor. And I'm doing my absolute best at picking up shifts at work. I'm trying to do odd errands for people to make up money to be able to pay the child support.
I'm assuming Ms. Baldwin would be more than happy to give you her email address right here and right now if you have a pen and paper.
Yes, I do.
If she has it, I can just put it in the chat. That's probably easier.
Or that. Are you able to see the chat if that, Ms. Stockwell?
Yes.
Okay, so Ms. Baldwin's going to send you her email through the chat. I'd ask that the amended return that you said was filed on the 9th of July, please provide that to her via email. And if you can put that, if all you can do is mail it to the clerk's office, mail it to the clerk's office. That address is readily available online. We're in a situation where I mean, I don't know. I know that you're currently pregnant. Is that correct?
Yes, I am due on the 2nd.
And the last thing we want to do is put you in custody, but you have obligations to other children that are still that are here already in the flesh, and we can't. We have to be considerate of those children as well. So we'll set this to the 1st. You need to provide email Ms. Baldwin by Thursday, the 20th, close of business with that amended income tax return, and please mail it to the court, the Superior Court Clerk's office, and then we'll review this on the 1st at 1 o'clock.
Sounds good. And we'll try to file an updated debt calculation for the court as well.
All right, thank you. All right, Gilliam and Gilliam 20-3-0042-908.
That matters, right?
All right, and I did see, let me see, there was an email that your office sent Miss Baldwin with an updated sheet. Let me just.
Yes.
I get so many emails, things get buried so quickly. Let's see here. When did you send that last week or was it earlier this week?
It must have been last week because my filings shows December 1. So it must have been last week. Probably Friday. Let's see real quick if it's in Odyssey now.
It is. Well, so I should have looked there first. Okay, so the respondent's debt calculation, I see the updated that was, it's dated from the Division of Child Support 11/29/23. Okay.
Correct.
Do we have Mr. Gilliam?
And not Mr. This is Mrs. That is the
Oh, I'm sorry. We have Miss Gilliam, which is, I'm sorry, Stockwell now.
Yes, she was. Oh, and there she is.
She's here. Yes.
Yes. So we're on here today for review regarding contempt. And my concern is we really have not changed course. If you look back through the pleadings, we've started the contempt back in April. It took us some time to serve Ms. Stockwell. We were before the court, I believe in June. And then we had a review, and then we set this review out even further. The issue here is that when you look at the debt calculation, we have no child support payments made in January going all the way to June. We have her basically getting served, the court kind of giving her some ultimatums. So we see a small payment in June, a small payment in July, and then once again, nothing in September, nothing in October, nothing in November. Here we are, December. So if you look at this sort of little debt calculation just for 2023, and assuming, here we are December, not seeing any payments made. So essentially over the course of a year, we have 2 months out of 12 where anything has been paid. And I always have a concern when somebody pays nothing, month after month of $0 paid. So it's not, I couldn't scrape together 20 bucks. I couldn't scrape together anything. And so that does get to where we're talking about intransigence, is somebody who just says, not going to do it, and you can't make me. And that's where the teeth of the sanction, unfortunately, need to get sharper for Ms. Stockwell. My client's been very patient. We've kicked this out, for not just like a month or 2 weeks, get a payment, but sort of like months at a time, saying, hey, kind of get it together and start making a plan and start making payments. And Ms. Stockwell just, instead of sort of taking that grace from the court and from my client, has kind of just blown it off. At this point, we've been at this again since April when we filed the contempt. We're kind of done with some of those simpler encouragements. And we're at the point where we need some teeth to get Ms. Stockwell to get real about the fact that she has to make payments. She has to pay child support. So at this point, I think what is most appropriate, we've got a couple weeks. So either I'd like to come back on the 26th, or in my preference, it's 26th because Your Honor is here. And I know that the docket changes in January. But essentially, I'd like to see some real payment this month. And if she doesn't, that she shows up on the 26th in person, ready to spend some time in jail until she writes a plan on how she's going to pay. Because so far, none of this has gotten through to her, and it's been an extended period of time where these children who are entitled to support aren't receiving it.
Thank you. I just, for the record, I do see that, so there was an order on contempt that was entered in June for the April contempt. And then there was, it appears, a satisfaction or partial satisfaction, a judgment in July after another, after the amended tax return was ordered. And then in August, there was another $250 in attorney's fees ordered. I'm assuming that, or has that been addressed? No.
She has not paid those. And we've tried to give her credit anywhere where it's appropriate to do so. And you can kind of see from that debt calculation that in August, she paid a little bit over the total arrearage, I think by about almost $300 over the sort of monthly amount towards the arrearage, which was good. But then once again, no payments thereafter.
All right. Ms. Stockwell, any updates for the court here?
Yes. So we have been trying to figure out how to piece together a plan, because the day after I had my baby, we got hit by a drunk driver and my car got totaled. So I haven't been able to return to work for lack of transportation, and lack of childcare for lack of transportation. And we've been scrapping together and trying to piece together money, and neither of us felt like the $20 would make a difference. So we've been trying to make sure we are able to pay a lump sum so it doesn't look like we're just, here's pocket change sort of thing. We've been trying to rework billing. We've put off paying multiple things, just trying to come up with the money. right now we're in this space where if we have to choose between paying the child support or paying rent. And I can't in my right mind put my brand new baby and my stepdaughter homeless to pay my ex money for the kids when he's making more money than we are on a regular basis. I would absolutely love to be paying them. I would love to be able to help support them. That is my goal. And my boss is very understanding about the fact that I can't get to work. She said, as soon as I am able to get transportation, I'm able to start right back up. We've been keeping in contact every 15 to 14 days to make sure that I'm still trying to find a car. I've reached out to family members to see if they'd be able to help so that I can get back to work and get back to paying. Where there were payments to the child support, those were months when I had a steady job and had finally gotten all of the auto like taken out of my paycheck directly sort of payments, so that it was one less headache of trying to schedule payments and get everything figured out. I have applied at jobs for stay at home. There's not many that are actually hiring. Just kind of a, hey, apply, and then I never hear back from them. I just heard back from a job that I applied to in January saying that they were full and didn't need anybody. But I've been applying for jobs stay at home wise so that I can still be able to put money towards this. But if the $20 is going to make a difference, I will send the $20 we have, or the $5 or whatever we end up having left over. I will gladly send it. I just didn't think that was going to make that big of a deal, or even really look good to the court's eyes for me to be sending pocket change. So my apologies for not knowing that that would be such a big deal. And that's about all I can say right now with not being able to even get to work currently to help pay for this.
Briefly.
Yes, just so I just want to confirm. So, and I'm sorry to hear about the car accident. Nobody was injured. Everybody's okay, other than the car, I guess.
No lasting injuries.
Okay, I'm glad to hear that. Yes, Ms. Baldwin, go ahead.
So unfortunately, these are sort of similar story, different day. Anytime we come to court, it's always sort of a woe is me. Gee, all these things have happened. And perhaps that would make sense to consider if we were in a situation where I set the review like 2 weeks and we were sort of dogging her the whole time. This is a case where we are setting reviews out months at a time, giving her an opportunity to sort of get it together, and she never does. She makes these choices of, I basically want to be a stay-at-home parent to this new child that I chose to have and to my boyfriend's child. Instead of, the boyfriend has an obligation to take care of that child. That is not her obligation. So these are choices that are being made, and perhaps collectively between her and her boyfriend, but there's ones where they're consistently over a year, 10 months out of 12, deciding that the 2 children that she had with my client deserve $0. So again, we're making choices, and she's had a year at this point, or since April, I guess, since we filed the contempt, to get these things together. She just never does. And unless there are some true teeth to the court's order, she is never going to do so. So that's where, we've put it out long periods of stretches, hoping she would get things together. She just isn't. And unfortunately, we need to have a harsher penalty. And I believe that will unfortunately result in action, because so far what we've done has not resulted in really any action on her part. It's all, gee, I wish I could, but even now there's no stated plan on how she's going to pay. It's completely vague of, here's what I'm doing, here's what I've done. It's sort of all, well, if something comes around, I guess I'll pay, but that's about it. That's not appropriate when we're talking about child support. The children in my client's home, they don't deserve support. This is a court order, not a, gee, we'd like you to do this some period of time.
So, I understand the frustration. I understand, Ms. Stockwell's, circumstances. We unfortunately, it's unfortunate the court often sees, folks have kids and without the forethought about how they're going to support those kids. And in this case, it's, I understand the frustration here. There was an order of child support entered in January that changed the support, the temporary support, and in the most recent debt calculation, it appears that, as Ms. Baldwin stated, there was a payment made in July of $90 and August of $780. For a total of $870, and the arrearages just for this year alone are over $5,000. So while I understand making decisions between being homeless and providing for other children, there is an order in place. So here's what I will set a review for December 26th at 1 p.m. I would ask that Ms. Stockwell be present in person on the 26th at 1 p.m. However, Ms. Stockwell has until December 15th at noon, so that's next Friday at noon, to provide a plan to Ms. Baldwin's office regarding payment of child support. As you know now, Ms. Stockwell, some payment is better than nothing. No payment is kind of like a middle finger to those other two children that you have, and that's not appropriate at all. I appreciate you saying, well, we want to give bigger chunks. Doesn't matter. Frankly, the court would see a $25 a month, $50 a month payment as much better for everyone than 0, 0, 0, 0, 0, 0. If the plan that's provided to Ms. Baldwin's office is acceptable to Ms. Baldwin and her client, that date on the 26th can be struck. And if you want to renote it for another review, by all means, we can do that. If it is not acceptable by Ms. Baldwin, and so I'm putting the ball in Ms. Baldwin and her client's court for this, if that plan is not acceptable, then I expect Ms. Stockwell to be in person for court on December 26th, 2023 at 1:00 p.m. on the second floor of the Hall of Justice. And I guess the implication, Ms. Stockwell, is the court is most definitely considering jail time in lieu of child support, as this is just, it's gotten out of hand, and it's only going to get worse and worse the longer non-payment happens, and those arrearages are just going to keep growing, and then interest will start applying, and it's not good for anybody. Okay. So Ms. Baldwin has the authority to strike that 26th. And if they don't feel the plan is sufficient, and frankly, if there's some negotiation between the parties after you review the plan, I'm fine with that. I feel like Mr. Gilliam and Ms. Baldwin have been willing to work with you, Ms. Stockwell. So, you know, the sooner you get a plan to them, the more opportunity you have to have some discussions with them about how you're going to address this moving forward. Okay. Any questions or concerns?
No, Your Honor. Very good.
Thank you.
All right. Good luck.